in digital evidence. One is it is volatile. And that is why collecting that evidence must be done in a proper way. So digital evidence can quickly disappear by being overwritten or deleted. Data stored on RAM system memory will generally be lost if the computer is shut down. Now, you go to a place, like now I found that your computer is running, my computer is running. Whatever is you can see here is whatever is found in the random access memory. Random access memory stores the data when the computer is on. The moment you shut down that computer, that evidence is gone. So that is why it is volatile. So that evidence is gone. So that is a challenge in collecting evidence, digital evidence. So what do? You go to a place, the computer is on. Don't turn it off, because you are going to lose the evidence that which is in the RAM. And maybe that evidence is what you needed in the court of law. So how do you collect what is in the RAM first before you collect the other information? So that's rule number one. When you find the computer is on, don't turn it off. You are going to change the evidence. Okay? The other thing about the evidence, digital evidence, that is fragile. Digital data is susceptible to alteration and can easily be manipulated, altered, and damaged. It's fragile. And that is why we were talking about picking this background and putting it there. Photoshopping. I can change it. You can manipulate it. So how do you convince the court that this evidence has not been changed? And that is why it is fragile. How do you convince the court? You convince the court because the process you use to collect that evidence is methodical and systematic. That is when the court will know that it is this evidence has not been changed. Otherwise, if you cannot convince the court that it is the process was methodical and systematic, how will they accept that evidence? It will not be admissible. Decentralization or decentralized storage, that is the ability of the cloud or remote storage, has influenced the way information is stored. And that has affected the way even you do the investigation to collect digital evidence. The cloud, you don't even know where the digital evidence is stored. And that is what you want to use to rely on in the court of law. But it is not stored there. There's a time a group of investigators went to a certain organization. And then they were told, my friend, the data that you are looking for is not here. But they still insisted of collecting the computers, only to find that there is no data at all. So the cloud actually complicates the investigation of digital evidence. And also the speed of technical development, the way things are developing so much, the fast development. We have AI, machine learning, all this have got effect in collecting digital evidence. Admissibility of the digital evidence. So digital evidence must be collected in compliance with the existing national legislation and best practice to ensure admissibility at trial. Each and every country has a piece of legislation on how that evidence should be collected. And you must use best practices international best practices just to ensure admissibility of that evidence in the court of law. First of all, legal authority. The investigator must ensure that they have the legal authority to acquire and collect digital evidence. We talked about here, I talked about the search warrant. When you are doing a search warrant, make sure that your search warrant take into account every device that you want to do the investigation on. Because if you leave one of the devices and that device, the device has got the evidence that you want, it is not going to be admissible in court of law. So the legal authority, you must have the legal authority for you to collect that evidence so that that evidence will be admissible. Without the legal authority, that evidence, even if you use the best method and the best practice to collect that evidence, still not going to be admissible because you are lacking the legal authority to collect that evidence. The other thing is authenticity. It must be shown that evidence is what it purports to be. It must be authentic, which means that it is genuine and matches the claims made about it. Is it genuine? The evidence that you are bringing to court, is it genuine? And for it to be genuine, it has to be proved to be authentic. There's a case where I was an expert witness. The prosecution had done the investigation and presented the evidence in the court of law. One of the evidence, the main evidence where was a video file, and an audio file. So I was given the report by the attorney, the defense lawyer. I was given the report. I went through the report. So I went to court to dispute this report. And eventually, the guy was acquitted, just for simple mistake. We are talking about authenticity of this evidence. Do you prove to the court that it's authentic? So these people had used a device to do the recording. Once they recorded the device, using that device, they transferred the recording to a CD. And then they brought the CD to court. So when I watched the first thing I did is to watch the video. The video normally has got the date. Sometimes some video has got date there. Okay. So when I looked at the video was reading, the case was in 2018. It was reading 2014. So I asked, is it authentic or not? That and other things that I'm going to tell you later as we go on. That actually made this guy to win the case. Authenticity. Relevance. Forensic relevance is determined by whether the evidence establishes a credible link between the perpetrator and the target or the crime scene. Was it relevant to this case? The case is 2018, and this thing was done 2017. What is the relationship? Is it linking the victim? And it is not. It is not relevant. Those are the things that court must look at. The integrity. I can't talk this more. That is the only thing that you need to prove to the court. That the evidence you are bringing to court, nothing has changed. It has not been changed in any manner. The integrity of that evidence is intact. Then it is admissible. Without that, it is very difficult Like now, we were doubting the integrity of this evidence. Why we could not establish integrity? The second point was, here's the report that I'm looking at. And in this report, the device that was used to do the recording, there's no mention of the name of that device. There's no serial number of that device. There's no model on that device. So how do I depend? How does code depend on this recording without any background integrity of the evidence? You have to show that this integrity. Secondly, the device is here with no name, no serial number, no manufacturer. And then the content of this device is transferred to a CD, which is being brought into the court of law. In the report, there is no explanation how this process took place. Remember what you say, that you have to prove the court that the process is methodical and systematic. But here's a report I have. First of all, the video itself is reading some other date. Secondly, the device has nothing to tell us this is the device that was used. Then thirdly, how this device, the evidence was transferred from this device to the CD to be brought as evidence in court. Nothing was there. On this basis, it was thrown out. Okay? So, integrity of that evidence must be proved. If you have to put in place methodical and systematic way of how you collected that evidence from the time you collected it to the time now you're bringing it to court of law. That must be very clear. That is what we call the chain of custody. We are going to look at that. Reliability. There's nothing about the way in which the evidence was collected and subsequently handled that cast doubt on its authenticity and veracity. Yes.
I would like to take you back a bit to the point on legal authority.
Yes.
Of evidence. There is a collision between invasion of privacy and evidence collection, of course, because I think many constitutions provide for privacy of a person, and when you are collecting evidence, especially when you are not a law enforcement officer, you might be you might be entering their privacy illegally. Don't you sometimes encounter such challenges, especially for gender-based violence? This comes most often when someone claims not to be recorded or to be taken footage, so that it's their privacy. They claim their constitutional right of privacy, and then there is evidence correction. Yeah.
Remember, when we talk about legal authority, ensure that you have the legal authority to acquire and collect digital evidence. Which means that whether you're a police officer, a law enforcement, still, for you to go and collect that evidence, you need legal authority. And this legal authority comes in the form of search warrant. So even if you are not a law enforcement, there's no way you are going to collect evidence without a local authority.
So I'm talking of a victim now who is preparing for his or her case to be prosecutable. So that if instances are occurring, then they are recording so that they can have, in the end, evidence that they can present. We know of a case that recently was in court, like for instance, Prince Kid. It was just the victim who was recording the information and presented them to court. We didn't maybe read the judgment, but I always ask myself, how about the privacy of a person if it collides with evidence collection, especially being done by the victim who wants, let alone justice?
I don't understand. Is the victim that is collecting the evidence or the police officer or the investigator? Yes.
Actually, the question is, as a defense lawyers, normally here in Rwanda or in many jurisdictions, this investigation is conducted by investigators or prosecution. Then you collect from the victim a phone, for example, mobile phone or computer. Then the victim will inform you that this video or these photos, I have taken these photos from the crime scene, for example. Then the investigator and the prosecutor took the evidence to the court. Then you, the defense lawyer, you want to challenge these evidences. And remember, here in Rwanda or in many jurisdictions, only public institutions, public are only allowed to conduct such investigation. So how can we challenge such evidences? Because, for example, you can provide a fake video. So you want to conduct your own expertise, your own investigation. Because I had one case sometimes back where I wanted to challenge a document. Actually, the report was made from a forensic laboratory. They was showing that the document was false. Then I wanted to challenge that document because the report was saying the document was false, while the original copy of the document was kept by the defendant. And the defendant never submitted that original document. So I was looking away of challenging that report. Of course, you cannot go back to the forensic laboratory. They cannot admit that because you are not a public organ. I contacted one institution in the Netherlands. They told me that we only deal with public institution. So on that fact, how can you challenge that?
Now, here is a case where, if I can understand you well, is a case where the victim has collected the pictures, and then the prosecution is coming to rely on that. Now, there's a case in Kenya which was similar. It was some sort of a, but it's a similar, I can't remember well. But you see, this is where a TV station, the journalist collected the information, and then they ran that bit on the news, okay? Then the DCI came that they wanted to use that as evidence. And they took the evidence, they presented it to the court of law. It was thrown away. On the basis that the person who collected that evidence was not produced as an expert witness in the court of law. So in this case, for the police officer to rely on the victims, and you never know what the victim, how the victim collected that, I think that evidence will not be admissible in the court of law.
Thank you. Maybe we need to take into consideration the legal perspectives and the practice of different countries and the laws and legislations that are being used in those countries. And maybe when we are going to discuss that issue, we need not forget that in our mind. Legal practices are different. Common law practice from civil law practice. We have laws here. They are clear and actually defining what is it. And another thing I want to elaborate more is we need to understand forensic evidences and digital or electronic evidences. Those things might be somehow different. If someone goes, and maybe we are here talking, discussing, he or she records what we are talking. And when time comes, he needs to produce that we are together talking about that. Then he produces it in a court as an evidence that you are the one who said this. And maybe you come as a defense lawyer, you say that I don't agree because you are not you don't have the legal authority to maybe to take the audio or the video. Under our laws, the courts will say that evidence is admissible as long as within the rules of procedures of the laws here we use. Maybe except in economic crimes, where you need to use a scientific evidence, you only need to have an authoritative power from institution to take that scientific evidence or that electronic evidence. But in other cases, actually we have so many leading jurisprudences, cases from Supreme Court, clearly defining that all evidences in criminal matters are on the same footage, are equal, as long as the defendants are given they are given a space and time to reason and argue against them or about them. Yeah, thank you.
So it's more of a procedural rules than looking at the scientific. Is it criminal and civil laws? Law? Both criminal and civil? Criminal. Don't you think that the burden of proof need to be very high? And that's why we need scientific proof. Because what I gather from you is that the victim has taken a video somewhere, and then prosecution or this authority comes and relies on that. It's still admissible, according to the Rwandans' evidence procedures. Okay? Then, yeah.
Was not yet produced from the factory, for example. Then the problem comes to the defense. I don't have the right to take that phone and bring it to the laboratory for the counter expertise. That is where there is a problem. Maybe you can hear from you, what about other jurisdiction? Because in some jurisdiction they have the private investigators where you can take to the private investigation. So how can you
challenging is just what I've given you. Remember what the case that I've given you, whereby one, the device that was used to collect the evidence is not present. You can challenge then that ground, which device was used we want to authenticate this evidence. Which device was used? It was iPhone. Which type of iPhone? Which model, which serial number? Those needs for the evidence to be admissible, those need to be established. That is what we call the chain of custody. Now, that video itself, which was taken, that video. First of all, you need the metadata of that video. Okay, that evidence must be presented by metadata, and that video actually must be, for its integrity, you must present what we call the hash value for that video. Okay?
I have that video. So I need to take that video and bring to an expert somewhere so that he give me the details of that video.
Yes.
That is where I want to understand. Because myself, I'm a layman in that field. I need someone else who is an expert whom I will bring. But
the evidence itself with the video is now with the prosecution. But is it not allowed? I don't know what the laws are. Is it not allowed that you need to share that evidence with the defense?
You share we share the video with the defense part. But taking that video to an expert to analyze that video, the details, the tool which has taken that video, that is where there is a problem. Because here in Rwanda, the only institution which is allowed to correct such evidences, it is public entities. While the other part is not allowed for that.
I get where the problem is. It's more about the legal aspects rather than the scientific.
Actually, let me I'm standing to the forensic people. These are the new things people need to understand, and we are lucky. At least we are here for this course. It's not true that when you go to the evidence law, I'm the one who even participate for reviewing and adding all these electronic parties. The case prosecutor present an electronic evidence like a video, as you said. The judge from the law said, if you are not agree for admissibility, for whatever you said, the judge has to say, let us call two experts. Have you see? It's not you as a lawyer, because we need to be expert. Once you say, oh, can I take this mobile? It's not true. If you need a source of evidence, the judge said, okay, let us now call two experts. Call one your expert, and the prosecutor has also to delegate expert, maybe the same one. And then they sit and then produce the report. This is how the law evidence said. Maybe for soon you'll see that law. And another things he said, we are not having the access to the real phone. Actually, the things he said about these kids, what I know as a little informations, as you say about the cloud informations. There is a phone has been taken, the picture and so on, or whatever, and then the device bring to the judge was not the same, but the data was acquired and extracted from the cloud because we had these credentials. Means this data, this evidence we bring to the court, even though the prosecutor bring the phone that has been seized to the crime, was not the same informations, but the real data has been taken, actually has been from the cloud one. This is the case, maybe smaller than that one. But my friend, don't worry. Since you found that there is an evidence, and then you counter the issue from the source. Actually, the source is very important. You have to raise the issue by saying we need to do two experts from both sides. This is what we have preserved from our evidence law. Thank you. Yeah, the new one, actually. The new one has been,
okay.
Yeah, man.
Oh, okay. Yeah, because it has to be very clear. It has to be very clear from the legal aspects.
Thank you. To add more what he had said, as I've said, from the civil law practice, which is maybe quite different from common law practice. You know, in civil law practice, in criminal matters, judges are also active. Whereas in common law, judges, they are just there, they are neutral. But here in criminal matters, sometimes the judge becomes more active. For example, if you say that I don't agree on the admissibility of this digital evidence on the ground, this ABC and C, the prosecution also argues it. The judge now will become as an active judge, then will maybe say that, no, now we are going to establish the team of experts who go sit on this evidence, and then they do a report on it, if it is authentic or not authentic, if it would be reliable or not reliable. And then the report he produced, the team will produce, will guide the judge to decide the case if the evidence may be admissible or not admissible. Thank you.
Yeah, just to add on that, I think what also needs to be done by the judiciary is that in most jurisdictions, what needs to be done by a judiciary is to come up with the procedure for digital evidence. Now, if you look at the Interpol, they've come up with that document. How do you collect? That is what we call the standard operating procedure for collection, preservation of digital evidence. That must be shared by the judiciary and the law enforcement. Then this problem that you are talking about will be finished. Okay? So integrity is very important. And according to our law, we have the evidence law, the Evidence Act. In the Evidence Act, there's a way you should present that evidence in the court of law. Like if we go take case I'm telling you, if I take the evidence, digital evidence to court, I must observe the section 106B, which requires me to that evidence I'm present must include a certificate. A certificate will show things like what device did I use to collect this evidence? Was that device in a proper, secure, functioning securely when I was collecting that evidence? Who is the authorized owner of that evidence? That must appear in the certificate, and the certificate is not. There's no prescribed kind of format of certificate. It can be in terms of just affidavit, okay? But it must be accompanied by a certificate. And there are around 3 cases involving the election cases, election petition. And these 3 were dismissed on the basis of the evidence. One, there was a case about the governor election. And the guy who lost took case to the court. And the case, they came up with a video on a CD. And this video was taken by a mobile phone by his agent, who saw the clerks putting ballot papers, stuffing the ballot papers into the ballot boxes. And it came very clear. So they took this to court. It was dismissed. First, it was dismissed on the grounds of what I've talked about. The device that was used to collect, there's no information about that device. No serial number, no model, no nothing. Secondly, the CD, the process of transferring the video from this mobile phone to the CD, that process was not there. So the judge said that for auditability purposes, that information must be there. So that if somebody wants to audit the process, they can be able to audit. So as long as you put the method, there's a methodical and systematic way of how you collect that, you can prove to the court, then that evidence would be admissible. And if that one is missing, then we doubt the authenticity and credibility and the integrity of that evidence. So these are some of the characteristics that the court is looking at when you are they are determining the admissibility of evidence. So when we talk about reliability, if we talk about nothing in the process of that, whatever you are doing can cast doubt on the authenticity of that evidence, which means that you have to show in your chain of custody, you have to show that this evidence, this is how I collected it. I used this type of device. This may be, if there were challenges you have to put there, that is what so the reliability. The other one is about credibility. Now, credibility is more of the person, the expert who is doing that job. Is it if I'm an expert witness, my credibility, I'll prove prove my credibility to court in the sense that I can show the court that I'm qualified to collect that evidence by my credentials, by my training, and by my experience. So if and that is why when I go to court normally, what the court requires that I do my report. After doing my report, I have to attach my certificate. My certificate shows that yes, I did computer cybersecurity course. I have to put my experience, my CV. I have to put certified copies of all my certificates, so that as I go to court, they're in the report, but as I go with the original. So as I'm testifying, my certificate goes around, the prosecutor look at it, the defense lawyer will look at it, the magistrate or the judge will look at it, okay? To show that the credibility of that the evidence is shown because the guy is qualified. Secondly, what are this? Whatever I'm saying is worthy of belief. It's coming from the mouth of an expert. That puts more admissibility aspect on the digital evidence. And the last one is the validity. One way to demonstrate the digital evidence is reliable is by showing that it was collected in a valid manner. Whether scientific principles were used to preserve, acquire, and analyze digital evidence, and standards were met to handle the digital evidence. Now that is the problem I'm seeing there. Because I've taken a picture, a video using my device, and then the prosecution comes and picks and uses that as in the court of law. What is the scientific proof how that evidence was acquired? So these are some of the things that the courts must look at. But it conflicts with the law, some sort of evidence procedure rules. Okay? So the only thing that can be done here is to come up with a digital evidence guide of which can be adopted by the prosecution, adopted by the judiciary, and adopted by the law enforcement. And then you add on that guide, you add the legal aspect to it. That's the only thing that I can see can help there. Oh, we are 1:15. We have eaten into 14 minutes of lunch. Gabriel? Yeah, we've eaten into 14 minutes of our lunch. So I think we just, with immediate effect, we just go for lunch and come back.
Much obliged. You know, when the Mwalimu speaks, I do not answer. A round of applause for Mwalimu. I think he's done tremendously well. He's taken us through the next couple of hours. So I think we can break off for our lunch break. We use an hour, Mwalimu?
Yeah. Come back.
Yeah?
An hour.
Yeah, so we'll use an hour and we'll break off our lunch now. As you move for lunch, so our lunch is served at in those tents over there. So you'll move out and then turn left, go straight into the tent. And as you're doing that, Brenna will be waiting for you at the back there for those who have not registered. There's a registration list that needs your attention. So bon appetit. I wish you all a very lovely lunch, and we'll see each other again at 2 p.m. Yeah. Thank you. Oh, sorry. For our online audience, bon appetit. I don't know, you must have had your lunch before. For those who are in different time zones, but those who are within the same time zone, please enjoy your lunch. Thank you.
Yeah, we would like to pick one. They are not available on the very secure because I know there is demand with law firms and everyone else. We can pick the next one.
I forgot to use the micro. In any legal proceedings, electronic messages shall be accepted and admissible as evidence irrespective of the sole ground that it is an electronic message, on the ground that it is not in its original form if the best evidence that the person adducing is it could reasonably be obtained. So in assessing the evidential weight of an electronic message shall be placed on the reliability of the manner in which the electronic evidence message was generated, stored, and communicated, as well as reliability of the possibility of its alteration. So these are the things that we are talking about. The reliability of how it was generated. So when you tell me that, this is where I find it a bit strange. You tell me that I go and do a video, and then the investigator comes and picks that video and relies on that as evidence. That's a little bit strange, because how reliable does the prosecutor have the information, how that evidence was collected, how that evidence was preserved, and how that evidence was extracted? Is there that reliability? So that must be there for the digital evidence to be admissible in the court of law. Authenticating digital evidence. When you are authenticating digital evidence, we have content generated by one or more person, like a text or text mail, email, or instant messages, and word processing documents such as or Microsoft Word. We can also have content generated by a computer or digital device without user input, something like log. And that's very important. That's an important evidence. It is the computer that has generated that without intervention, human intervention. And we are going to look at, when we are looking at avoidable and unavoidable evidence, we are going to look at such kind of evidence. Then there is content generated by a combination of both. That is, you are having a spreadsheet like Microsoft Excel, and you input their data, but Microsoft Excel will also do its input by doing automatic calculation. Then there is also content, device-generated content. So when authenticating digital evidence, device-generated content can be admitted if it can be shown to function properly at the time the data was produced. Now, you see that contradicts the issue of the prosecutor picking the evidence from the victim and presenting it. Because can it prove that the device, when it was collecting that evidence, it was working normally? It was in a secure state. And if it can be shown that when the data was generated, security mechanisms were present to prevent the alteration of the data. So that is how we authenticate device-generated content. User of the generated content can be admitted if it is trustworthy and reliable. Now, this is a case in Kenya when it came to authentication of evidence. So electronic evidence should be properly authenticated in order to be admissible in court of law. Now, this is a case where you are presenting an email before the court, and you want the court to rely on that email as an evidence. That email must be authenticated before it is admissible in the court of law. So in the Republic versus Mark Lloyd, Stevenson 2016, the High Court ruled that email in question and the attached document were properly excluded from evidence by magistrates court as they were not properly authenticated. So here's a case where somebody just brought an email which has been printed and wanted it to be admitted as an evidence, and it was excluded. Why? because it was not properly authenticated. So authentication is very important because remember what we say, that evidence can only be admissible if it is authentic. It proves what that it is what it is. Yeah? So it would have been appropriate for the expert to lay the foundation by authenticating the emails through email technological footprints. So authentication is required. Authentication is required for where any real evidence is being adduced at trial. So authentication is very important. That is what makes this evidence to be what it is. So without authentication, that evidence should be excluded as from the evidence. Now, I was an expert witness in a case where email was needed to be authenticated. There was exchange between two parties, and then there was a dispute. So we had to do investigation. So I was supplied with various emails which were being exchanged between the two parties. So for them to be admitted as evidence, we had to authenticate it. So you need to authenticate it so that it can be admitted. So this is part of the email, and I can just show you how it is authenticated. For privacy reasons, I've grayed out some details there. Now, email is authenticated by looking at the email headers. Remember, we say that in the internet can never tell lies. Everything that you do will remain on the internet. So this is a case where I was forced to go to court with a projector. A court that it was a court not even in Nairobi. It was somewhere in the outskirts of Nairobi. But I was forced to go to court with a projector because what I wanted to show the court is that this email, I can prove that it came from this person to this person, okay? And it is a valid email, so you can include it as part of the evidence. So one of the things that we are looking is when you are authenticating an email, you are looking at the email headers. Email header, remember what I talked about, the metadata, data about data. So when I send email, apart from the content I'm sending, that email has got the metadata, has got what information about that email. And that information, you can only get it from the email header. So this email header, as you can see, I have what I call here return path. In the snail mail world, you always you see that when you send mail and the mail does not get the recipient, then the post office will say return back to sender. So this is the return path. Each email has got a return path. And that return path, what is the content of that return path? So that I know that this mail actually came from this email address. So the return path is there. And I've just grayed it out for privacy reasons. Now, the other thing is what we call DKIM signature. DKIM signature is a technology to validate the email domain from which that email came. So each and every valid domain must have a DKIM signature. So this email, being that it came from Yahoo, I was checking what is the DKIM signature of Yahoo. Okay? So that one I put as evidence. And each and every mail that I authenticate, I must attach this header. Number 3 is, you can see X Yahoo Newman ID, and there's the ID there. In case this person disputes that this mail did not come from him, then what we do, we can write to Yahoo and tell Yahoo, give Yahoo this ID, and tell Yahoo, we want you to get us a copy of that email from your server, so that we know that this mail actually came from Yahoo. Then the other number 4 here, you can see X mailer, iPad, blah, blah, serial number. That is when this guy was computing this email, he used an iPad as the device. And we can see the serial number for that iPad. Number 5 here is envelope 2. And you can see I've also graded, this is the person who was sent email. Okay? So I can see this email was sent to so-and-so, and it was copied to so-and-so. So with this information, I attach to that email that I know I can convince the court that this thing has not been manipulated. This email actually came from this party to this party, and there was an exchange. So by doing that and attaching this, then that email can be authenticated and can be taken as a valid evidence to be admitted. Now, there are certain principles when for digital evidence, when you are extracting evidence, and these 4 principles were taken from what we call Association of Chief Inspectors. It is which was a Scotland. It was a Scotland document, a Scotland Yard. So before the digital forensic took shape, these people already had started investigating crimes related, computer-related crimes. So they came up with some certain principles that you need to follow as an investigator for that evidence to be admitted in the court of law. The first principle says, no action taken by law enforcement, law enforcement agency or persons employed with those agency or their agents should change the data which may subsequently be relied upon in court. Any action that you are taking on that data should not change that evidence. If it changes the evidence, that evidence cannot be relied upon in the court. So if you know that this evidence is going to be relied upon by the court, ensure that your methodology or you have systematic and methodic ways of extracting that evidence. It should be able to, so nothing should be able to change it. It should be intact. The way it was extracted from the crime scene, it's the same way you are bringing it to the court. Now, this calls for one thing. When you extract the evidence, when you go to a crime scene and get the device and you want to extract the evidence, what you need to ensure is that you do not work on the original evidence. You need to make a copy of that evidence and then do analysis on the copy. And when I talk about the copy here, I'm not just talking about copy and paste. That one is not same as the original. Tell me, if I come to your computer and the file that has got the evidence is on your computer, and I take a USB and copy that file and take that file to court, and it is the evidence, can it be admissible? Why?
The copy to be admissible, you need to do what you call bit by bit. Means you have to take the whole entire, not only the content, even the entire file system of the storages as a copy, because this has to be, once you make a copy, you change the metadata as we said, but the copy remains within the timestamp from the evidence has been taken. So make a copy, you change the metadata. Thank you.
Okay, that's right. When I come and copy this file, there are metadata, there are information about that file that you'll see. You'll see that the date has been modified. And if the date, which means that is not the same file as the original. So, principle number one, never do anything that is going to change the data that is relied upon by the court. I do what we call bit-by-bit copy or forensic copy. Forensic copy means that if it is the entire hard disk, I'm copying everything plus empty space. Okay? So even if you're doing a copy and paste on a hard disk, and you say copy and paste, and you copy the entire hard disk, then look at the size. The size is not going to be the same, because the copy and paste is not copying the unallocated space. They are the empty space. They are not. It is not copying. It's only copying places where there's data. Copy and paste will not even copy the residual data that is in that particular device. So I do what we call bit-by-bit copy, which means that I'm copying everything, including empty space on that particular device, and then working on that particular copy that I've made. So this is what we call bit-by-bit copy or forensic copy of the evidence. And number two, in circumstances where a person, yes.
This gives me to think that whatever we use today as evidence in courts are not what we are supposed to be using. Because most of the time we use scanned copies, we use printed copies, and we do not go to the original, as you are saying. It means whatever we are using, we use non-original sources.
You know, this is a physical evidence. If I scan it, does not mean that this now it becomes as electronic evidence. It's just a scanned copy. All right? So if this is paper of evidence, I've just scanned it for purposes. But I know some jurisdiction, as much as you brought, if you bring that scanned copy, it must be certified. That is the copy of the original. That's when it will be accessible. But when we are talking about digital evidence, these are evidence that you cannot touch. It is not visible to the people who are not trained. So the method of collecting it must ensure that its originality is maintained. Its integrity is maintained. Okay? And that is why you do that bit by bit, because you don't want to work on the original. Okay? And we'll see why we need not to work on the original. If let's say you work on the original and something happens with the original because you've interfered with the data, the state of data, then automatically, if it's defense, they say that these people interfered with the data on the original. Okay, so that data has changed. But in digital evidence, if the defense or the prosecution can just prove that there's something that has happened on the data, then that makes the validity of that evidence completely inaccurate. Okay? So that is why you do copy. Now, number two says that in circumstances where a person has necessary to the original data, finds it necessary to access the original data, that person must be competent to do so and be able to give evidence explaining the relevance and the implication of their actions. If you can prove that now, this is the original phone. I hook my forensic here, and I collect that evidence. I'm accessing the original data without making a copy for this. The principle says that I must be competent. I have to prove to the court that I'm competent to do that. Okay, and I have to explain to give evidence, explain the relevance and implication of my action. I have to tell the court, yes, what I did not change the evidence because 1, 2, 3, okay? And I'm competent to do that. That is why you are told, if you are not competent to do that, don't try this, okay? So it is not advisable to work on to access the original data. Make a copy of that data. Number 3, question? Yes.
When you go back to principle number 1, to make sure that for example, the email is authentic, you need to make sure that the email is authentic. You need to have the original one in a soft on computer, as I think. Is it?
Yeah, you can have that, or what you do is, you see, if this, in most jurisdictions, if this is the computer that we are investigating, okay? Basically, the evidence is on the hard disk, all right? So when I pick the device to go and investigate, and I do bit by bit copy of the hard disk of this computer, okay? I make sure that after doing that bit by bit copy, I create the hash value for it. Hash value means that I'm taking the data when it is known to be good, and I do some mathematical function on that data, and it creates what we call the hash value, or the fingerprint, or the message digest for that. So if this computer is taken back again, all right, and they put the hard disk back, and then they delete the data, okay? And later on they came that you are lying because the data that you are talking about is not there. So what do? I bring the copy that I made. It has got the hash value. Not the physical copy that I made, or even not really the physical. You make the image on another storage device, so it will be actually what do you call it? Soft copy of the original. I've created the hash value. Now they go and change the data, and then they come back and say that the information that this person is bringing here does not exist on this computer. So what do? I tell them, bring that computer again. Bring the hard disk again. Let's create a hash value, a new hash value on that hard disk, and compare it with the hash value that you get when we started doing investigation. If they change something there, the hash value is going to be different. So if the hash value is different, you know that they have interfered with the evidence. Are we together there?
Yes, we are together, but I'm trying to see how it will be useful for the defense lawyer. Because in most cases, we used to get some extracted messages from the mobile phone in different dossiers. So the devices and the soft copies of those things are on the other part. So if you are the defense lawyer and you want to check that, you need to have that soft copy. You need to have that phone. You need to have that laptop. So I'm trying to see how the defense side would challenge that.
Go to point number 3. Okay. An audit trail or other record of all processes applied to digital evidence should be created and preserved. An independent third party should be able, what is the problem? Be able to examine those processes and achieve the same results. One thing is, as a defense lawyer, you will insist, if there's a dispute, that you want the same device so that you can do your forensic extraction, okay? And that is why it is important to share that data. I don't know in Rwanda, but I know what I know is that you are allowed to share that data with the defense. Okay? Because if you cannot share that data, then let's go back to the audit trail. Show us the processes that you, clear processes that you did, that we can certify that exactly you did the right thing. That can, to avoid that dispute. Because, and that is why the most reason what you need not to work on the original. Because I'll resist, I say, I need to the original piece of device so that we can carry out our own investigation to see if we can arrive at the same results. But if the process are okay and a proper audit trail is important, is there, then you can see, you can convince the court. And that is why it is very important. We are going to see what we call chain of custody. From the time you're collecting that evidence from the field until that time, the time that evidence is actually brought to court, there should be a chain of custody. And that chain of custody should not be broken. When it is broken, then we bring the integrity issue on the evidence that is being presented in the court of law. Okay? So these are what we call the ACPO principles. These ACPO principles still apply to digital evidence up to now. Number 4, why is it doing this? Number 4 is the person in charge of investigation has the overall responsibility to ensuring that law and these principles are adhered to. Somebody in charge of that investigation. You must ensure that all these things we are talking about, they are adhered to, so that data can be admissible in court of law. What are some of the digital types of data, digital data that you can find? We have what we call the volatile data. This data can easily be modified or can be lost when the device is shut down and it is contained in the RAM. Now, this is a very important thing for the first responders. First responders, if you go to the field and you find the computer is on, don't shut it down, because you are going to interfere with the data. Secondly, you know, sometimes back when forensics, digital forensics just started, we used to call it computer forensics. There was the principle of plug out remove the plug from the wall when the computer is on, so that it creates a dump memory that can be later on be analyzed. But nowadays, the memory of a computer, when it is on, has got tons of evidence that can be there. It has got a lot of evidence that you can extract from that. So you are advised that when you go to the field and the computer is on, if you're not an expert, what you do is that you call the expert and you extract what is in the memory, because it is volatile. When you shut the computer down, that evidence will be lost. And once you extract that, that is what we call live forensics or memory forensics. You extract it, and then is when you shut down that computer and you take now more persistent data. So volatile data is data that is contained in the memory, and it will be lost when the computer is turned off. Now, another thing, these people, I told you about the dark web. These guys who are manning the dark web, one of them was, used to call himself Silk Road. I don't know whether you had a dark web called Silk Road. Alpha Bay. These are young guys who were manning this drug selling sites in the dark web. In the dark web. So, what happens? These guys, for them to be arrested, Ulbricht of the Silk Road was arrested, I think 2013, in San Francisco. And then the Silk Road was seized. We don't say brought down, we say seized by FBI. Then after that came another guy who was operating Alpha Bay, also for drugs. So these guys, normally, their computers are encrypted. The moment that guy shuts down the computer, you won't get anything there because it's encrypted. And encryption is an enemy of forensics. So what they do is that they work on the computer, and when the FBI comes, it is normally coordinated between FBI and Europol. That's how they track down these guys and bring them down. So when the computer is on, the computer has got the encryption keys in the RAM. And that is why when FBI goes there to arrest them, they normally go around 4 people. When they really have spotted that person where he's sitting, and they know that his computer will be on. And the FBI will not make a mistake of allowing them to shut down that computer. Because if they shut down that computer, the case is going to be weak. Because they are going to they will not going to get the data that they are looking for. But by taking that computer and making sure that they are logged on to their website, that Silk Road is logged on Silk Road because it's the administrator, they can now take that computer and extract the data. Now, if that person happens that before the FBI reaches them, they shut down the computer, then that computer, they will do nothing because it will have been encrypted. So the best way is to make sure that they catch this person with the computer on. So that is important even for the first responders, that if the computer is on, do not shut it down. We are going to see that as we go. Non-volatile data is data that survives after a process with which it was created has ended. It is permanent and stored in the hard disk. If you are creating a Word file, okay, and you say save, and you put the path and you save it, that is non-volatile. It is in there and it will not go away. Then we have transient data. Transient data is data that is created within an application session which cannot be saved in a database. If you're logging on to your computer, to the internet, okay, and you see you are doing some purchase, okay, you see HTTPS, and then you do your transaction, then you log out, okay. That data is never created, is not stored in the computer. It is discarded data that is stored on computer when the document is deleted. We are going to see. But let me ask you, if I come as a suspect and I delete documents from my hard disk, are they deleted? Huh? Is data that is deleted from your computer is permanently deleted? Where does it go? Okay. There's nothing which is deleted in the computer. Now, we are going to see that. But if it is, when you're doing forensic investigation, you might find, if it's a picture, for example, you might find you extract a picture which is halfway. The rest you can't see. Okay? That's deleted data. You've just you recovered part of it. That's what we call forensic artifacts. We are going to see when we're on that topic. So that's residual data. Metadata, we've talked about metadata, data about data. So these are the kind of data that you'll be able to extract when you are doing your forensic extraction. Rules of evidence, digital evidence must be collected according to the existing national legislation, and this differs from jurisdiction to jurisdiction. Evidence has to be presented in court, must comply with the established rules of evidence. I think rules of evidence is particular to each and every jurisdiction. You may have your own rules of evidence. That is why sometimes you find that it overrules the process itself. If it is a scientific process, but the rules of evidence require that you do it this way, you see that in that point, you see that it overrules the scientific process itself. Rules of evidence govern whether, when, and how, what purpose proof of a case may be placed before the trial of fact for consideration, and best evidence rule is established to prevent any alteration of digital evidence, either intentional or unintentionally. So the best evidence is the original piece of evidence or an accurate duplicate of the original. So how do you get the accurate duplicate of the original? Using the bit-by-bit copy. So that bit-by-bit copy is the same as the original because if you want to see if somebody has changed, then you create the hash value and you compare the hash value. And we've talked about what hash value is. If I know the information, if I'm creating the information, yes, I gave you an example of a contract. We are creating a contract, okay? So once we sign that contract in the system, we create a hash value. So you go with your contract, we give me a contract. By the time we are executing that contract, we create another hash value. And we compare the two hash value when the information was known to be good and the time of execution of the contract. If the hash value are the same, we know that none of us has changed the document. And if the hash value has changed, we know that if the value has not changed, we know nobody has changed. But if hash value has changed, you know that document has actually been interfered with. So hash value is a way of ensuring that the data is the same with the original. International Organization on Computer Evidence, it talks about the same thing as ACPO. There are 6. First of all, when dealing with digital evidence, all the general forensic and procedural principle must be applied. So you need to apply forensic principle, procedural principles to the evidence. You must make sure that upon seizing digital evidence, action taken should not change that evidence. Otherwise, it's not going to be admissible in the court of law. The third one is when it is necessary for a person to access evidence, that person should be trained for that purpose. Exactly what Akpo was saying. All activities relating to seizure, access, storage, transfer of the digital evidence must be fully documented, preserved, and available for review. Auditability, very important. Okay? An individual is responsible for the action taken with respect to digital evidence, and the agency is responsible for seizing, accessing, storing, transferring digital evidence, is responsible for compliance with this principle. So this is just talking about the same actions that were prescribed by ACPO. This is a place where you can get more information. This is called Scientific Working Group on Digital Evidence. Please, if you can just note that one down, Google it. There's a lot of information that you are going to get there about digital evidence, especially when you look at the documents here. This section of documents, you'll find a lot of documents relating to digital evidence that you can read and have to know more things about digital evidence. Sources of digital evidence. Digital camera, we know we can get pictures, we can get videos, we can get audio. Those are all the digital evidences. Okay? We have mobile phone, a lot of evidence. We can get pictures here, videos, audio, text messages, call logs, voicemail, applications use, social media accounts, cell site, contacts, location data. All this is something that you can get from a mobile device. Laptop, the same things that you can get there. Mobile devices, same as mobile phones. Storage devices, where here we have optical discs, we have hard disks, everything you can get from now it just depends on what you are looking at and the methodology that you are going to use. If you are extracting data from a foreign, a mobile phone, the methodology is different from extracting data from a laptop. You need to use different methodology. Okay, so it is the methodology that you are using to extract that. If you are extracting data from a vehicle, a driverless vehicle, driverless vehicles, they have a lot of data there you can extract. So these are all wearable technology. All this has got digital data that you can extract. If it comes that now you have to, this guy, we think that he stored that information in his on his watch, then you need to extract that information from the watch, and that watch becomes the X bit in the code. Okay? Yes. First of all, before I answer that question, you see that the site I've shown you, this site. This site. Go to the documents here, and you'll find something on audio, how to authenticate audio. But in short, you have to prove to the court that you used scientific method of authenticating it. Now, what happens is that I cannot authenticate the video without your voice. So I'll need to get you. You need to speak, and then I need to compare the two voices. Yeah, I need to compare the two voices to see whether they are the same. It's a difficult area, and that's why you see even the courts really need to be. You need to prove that this recorded voice is the same as this person talking. But it's difficult. But there are certain scientific ways of doing it. I don't just exactly have the proper method of authentication. Yeah, but it is possible. Yeah. Mm-hmm. You have something? Uh-huh.
So in our lab, we have these technologies recently. It's a technology, of course, as you said, since this voice is under question, like a voice note from the court. So to confirm this is exactly the real person you are talking to whom, we call the victim or the suspect, and then we take some samples of the video as original, and then we compare.
Yeah.
So technology are there, even not one technology, two, more than that. So the same to the video, it could be even compared. So can compare the video and say maybe this video has not manipulated or modified or something happened to that video. But most of the cases for today now, we can even compare the light. If you take the voice note from the phone and then you say it's not me, so we are able to confirm that one using the methodologies plus the technologies.
That is available, provided the technology cannot be disputed by the court, and then it is going to be yeah. This. Yeah.
Thank you. Jacqueline Babas is my name. My question is, what if the subject is dead? How do you authenticate that?
I think they have the technology and the experience, so we can learn from him. In the lab, they have the technology in, at the institute.
Of course, for investigation purpose, since the victim say, oh, maybe the one has been dead, so we have the voice note, but this guy has been disappeared. Not even dead, disappear. Let me say it's disappear. So for the purpose of investigations, we can even check from other authentic voices confirmed from both parties. Since, for example, we do able to get the voice, but it has to be confirmed for both. I came within the voice, but say, this the service provider has been now have this kind of the voice. So since the party confirmed to be compared, actually most cases, as we said before, not all getting the original, but sometimes could even get some certified documents or like voices. If it is confirmed, yes. Look at, maybe sometimes this guy has been now keep saving the voices from somewhere on the devices. It has to be authenticated, and let alone it has to be confirmed, discussed in the court. Hey, could we use this one as the original? It is a copy because don't have this person. From the social media, people used to be keep recording their voices anywhere. But the problem is to be agree for both parties to be used as the copy or as the copy from the original. So it has to be discussed through investigation and through the court. But normal practices, you need to be having the real person.
Okay. You're satisfied? Yeah. Another question up there.
I had a question on today, like in the advanced technology we have today, there's something they call deepfake technology, where it's very easy to manipulate a video, and it's very hard to figure out, to distinguish between reality from fake. Let's say we are sitting in here, I'm here, I'm seated, but then someone kind of manipulate it, and then my colleague Jack is the one who is sitting here, or someone else. And they can manipulate that evidence through any technologies available for courts to use to detect such deepfake technology, which uses very high codes and such stuff like that. What is being done, basically? Or have you ever encountered such a thing?
Yeah, deepfakes is something that is new. In the forensic world, personally, I've not researched on how to investigate deepfakes, but I know that since the deepfake technology came out, the forensic world is not sleeping. Even though I can't give you a direct answer now, but I know that something has been done. It is not a matter of me. I've not done any research on the investigation of defect as at now. Yes, there's a...
Thank you. My name is Etren Hagara. I'm from Rwanda Bar Association. I would like to ask that nothing cannot be disappeared from the computer. Even if you delete it. Now, I'm asking if, for instance, I have, as a practical case, I had one of my client. He's a German. He was sending me emails. At the end, when I took him to court, I'm now remarking that the emails are no longer on my device, my computer. So And now I'm asking, can I retrieve these emails since the sending device is with my client in German while I'm in Kigali?
What has happened to them on your computer? They just disappeared.
Yeah, I suppose that he's the one who deleted these messages, that the emails which were sent to me.
But they were coming to your computer.
They're coming to my computer.
So
Because my email is installed on my computer.
on your computer.
Yeah.
So
But now they're no longer existing on.
but how is it deleting them when they're in your computer?
No, he deleted the original emails.
And
Now I'm no longer retrieving these emails. Yeah. They are not,
what email client are you using?
you say?
What email client are you using?
He was using an email.
No, your computer. What your computer? Do you use Outlook? Do you use what? Do you use Gmail? Do you what?
No, I use yahoo.fr.
Yahoo.fr.
Yeah.
Who has got the authority on this? Do you think he has got authority in that access to that email?
No, I don't know if he has authority or
One possibility is maybe you shared with him your email credentials, and he has got access to your email. The other thing is if you can get those emails, then you remember Yahoo. If you can get those emails from him, then you remember Yahoo has got the ID for each and every mail that is passing through its server. So you can read them from Yahoo if you know the email ID. But if you are, the problem which I told you we are facing is where these service providers request from Africa, they don't actually really act on them. So it becomes quite frustrating when you're doing investigation involving these people like Yahoo, Gmail. And that's the problem I have now. But what I don't understand is only if somebody had got, or there's a setting on your Yahoo mail that deletes emails after a certain period of time. That could be the reason. So you need to, if that the setting is there, you need to check the setting. The other thing is, if you are using Outlook, then I could say that in your setting, you put that when email is delivered to your Outlook, then you tell your Outlook tells the server to delete it from the server. Okay, so when it is deleted from the server, you can't get it, but it will be resident in your Outlook. That's why I was asked you if you are in any way you're using Outlook as a mail client, that is what we call receiving and sending mail. We call what we call POP3 and SMTP. SMTP is for sending email. POP3 is actually for popping mail from the server into your local computer hard disk. Okay? But if you're accessing it outside, which means that it is not resident on your laptop or your computer. It could be a setting that is deleting it from that mailbox. Okay? Internet of Things. Internet of Things. Everything nowadays is communicating to internet. Provided it has got, we have now the internet, we had the IPv4, which is almost depleted. Now we are going to IPv6. We've gone to IPv6, which has got a lot of devices that can be connected to the internet. So this is an area which you can get a lot of data. Types of Caesar. This is what we talked about, that when you go to a crime scene and you find the device is off, what you need to do is just take a copy of that device and then take it to the lab for analysis. When you are analyzing a device which by nature is off, is not on, it is off, that is what we call dead forensics, dead box forensics. The device, it is off, is not on, is dead box forensics. So you can just confiscate that equipment and then take it to the lab. Or you can do what we call imaging or mirroring. What we call the duplicate copy or bit by bit copy of the original, so that you can, you don't work on the original. Or you can seize by taking the backup. Then you go to a place and you find the device is on. Don't put that device off. What you need to do is try to extract data while that device is on. You try to get the data which is on, evidence which is on the RAM or the random access memory. You can go to a place and the evidence you are looking for is actually on those people's server. You cannot take a server to the lab. You need to take the evidence from there, extract the evidence while that computer is still running. And that is what we call live forensics. You can also seize the evidence from, in this case, this is what we call open source investigation. Okay? Open source is that you are extracting data from publicly available sources like the internet. So internet is actually the big source of open source. Okay? Open source intelligence. So once you collect the intelligence from the internet, you can convert that intelligence into evidence. Now, this is what we call data acquisition. Okay, this is the bit by bit copy. In this case, you can see this is the device, the hard disk that has got data. This one. Okay. Now, don't want to work on the original piece of this device because I might interfere with the data. So what I do, I copy the content of this data into another media. But I'm very careful. I don't want to contaminate this original. So we use what we call write blockers. Write blocker is like a glove, hand glove. When you go to a crime scene, you don't want to touch anything. You have to put the glove because you don't want to contaminate the crime scene. So this is, in digital world, this is what we call the write blocker, and it acts as a glove. So the content, I want this content to go to another media on this side, which I've attached to this black fingerprint. So what happens is that, what is the function of this? The function of this device is to ensure that data is copied from the original to the media that I need to copy into, but not vice versa. It is preventing data from copied from that media back to the original to contaminate this original evidence. And this is what we call the bit by bit copy of the original. So I'll work on the media that I've created this side. Okay? Chain of custody, very important. Chain of custody means that is a chronological documentation or paper trail showing the seizure, custody, control, transfer, analysis, and disposition of physical or electronic evidence. When you are going to court with evidence, digital evidence, you must have this chain of custody form filled. Okay? It shows from the time you collected that evidence, what you did to that evidence, how you preserved that evidence. This is going to actually convince the court about the reliability, the methodology, the systematic way of how you collected that evidence. Okay? And it adds to the integrity of that evidence. So, chain of custody, to maintain chain of custody, you must preserve evidence from the time it is collected to the time it is presented in court of law. To prove chain of custody, forensic investigator must testify that the evidence offered in court is the same evidence they collected or received. They must say that they have to testify to the time and to the date the evidence was received or transferred to another agency. That there was no tampering with the evidence, with the item while it was in their custody. So chain of custody should be initiated at the time evidence is recovered, and the chain of custody begins as soon as the seizure takes place, and it concludes when the evidence is returned or destroyed. So we need to maintain that chain of custody, even if this case is going for 10 years. When you come to court, you have to show the chain of custody. That will prove that the evidence has not been interfered with. So, one thing which is very important, just like you go to a normal murder scene, what do? You take take snaps of the body, how you found the body, how you found the crime scene, everything. Why do you do this? Because this is going to be part and parcel of chain of custody when you are presenting that evidence in the court of law. The same way, when you go to a crime scene, and this is the computer, you need to take photographs. You need to take photographs or video. And this is going to help you in two ways. One, this is the condition I found this evidence in. This is the condition of this device, because it might come that by the time you are returning this device, the owner claims that, oh, this guy has interfered with it. There are so many keys that are not missing here. So taking it at that point, before you touch it, will show that this is the original condition of the evidence. Any visible damage should be photographed and also documented on the chain of custody form. This is an example of chain of custody form. This is the first part, but this is not cast on stone. We can design your chain of custody according to your procedures. This is the second part of chain of custody. How many devices have I collected? 2 devices. One, Dell computer, blah, blah, serial number, and then the DVD read-only. Okay? And because there's no third one, I cross so that nobody can come and add another additional, because this is something that is going to go code. Some may add something. If I'm transferring the device from one place to another, it has to be signed off. If I've taken that evidence to the lab, it has to be signed in the lab. So you must have a logbook to sign, to actually making sure that the person receiving it is assigned. Because you see, a digital laboratory, if you tell us, it's a very sensitive place. And even the people that you are employing in the laboratory need to do what? Background check. Of course, remember, this is where you keep an evidence. And this evidence, I know I'm a big person, a big politician somewhere, and this evidence is going to take me in for 30 years. And my guy is working in the digital laboratory. What will I do? In Kenya, we can even ban that laboratory. Completely raised down. Yeah. Or otherwise, I'll make sure that I pay that person something to steal this. So that is why it is always important to have this chain of custody in the lab. somebody takes the digital device in, you sign it. Out, you sign it out. Otherwise, it may disappear. So it is a place that has to have very, very secure security in that laboratory. It's not. You'll tell us. Yeah, it's not a place that everybody gets in. Final disposal of the authority, if the device can be taken, can be disposed. In most cases, if it is something to do with drugs, you can't get that device back to the owner. It has to be disposed. It has to be completely formatted and maybe given to a charitable organization somewhere or a school. If it's a computer, cannot get it back to the owner. Or it can be, if you decide that it is being destroyed. So you can see the chain of custody start from the time it was collected to the time it is now being disposed. If it is supposed to be returned to the owner, remember what you did by the time you are collecting that device. You took a picture. So the owner cannot say that you've interfered with the device. So this chain of custody must be maintained. So from the initial seizure to the transportation to property store, examination, property store again, to the court order return. That's the chain of custody. And the chain of custody should not be broken. If you break the chain of custody, then you interfere with the integrity of that evidence, and the possibility of that evidence being not inadmissible is very high. Okay? Any question? That ends our part, session 2. Do we start another session, or we go? We break? That is when we have. It is. We are supposed to break at 4:30. It is 15:38. We take a 15-minute break, then we come back, and then we finish, because we have a lot of load tomorrow. So we do 15 minutes break, strictly 15 minutes. Then we come back and we finish the one for today. All right? Okay. That's our 15-minute break. ask people to come back. Earlier on, been talking about integrity. Hash function. Hashing is a mathematical function that you use to verify the integrity of data. At the time the information is known to be good, you create a hash value for that information. Then when you want to make a decision using that information later on, you create another hash value and then compare the hash value of that you created first with the current hash value. If there's a change, then you know that information has changed. So the three major ones that we normally is being used in the forensic world is the SHA-1, SHA-2, and SHA-384, and SHA-512, as well as MD5. Okay? So look at this information I've written here. Your loan is 5,000. What is the hash value for this? I come down here and look at MD5. MD5 is the most used one. Look at this hash value. Note it. And then come and look at SHA-1. Note the hash value. Come and look at SHA-256. The longer the value, the longer the digits or the texts. Okay, and look at SHA-512. That's the strongest. Okay, so if you check that, and then I come back here, we are disputing, and I change that your loan is 500, and I create another hash. Come down here, check, are they the same for those values? Are we together? Are they the same? Can I repeat it again? Okay. Originally, I put here, your loan is 5,000. I calculate hash here, and that hash is created. I come here. These are the hashes for that particular string of words. I want you to look mostly MD5. Just look at MD5 and SHA1. Because those ones you don't need to look all of them. So have you noted MD5 and SHA1? Have you noted that? Have you noted SHA1 here? Are we okay? Then I come, even if I add a dot, only a dot, like this, and calculate the hash. Are they the same? They're not the same. Which means that I've made change to the text. So the integrity of this information has been interfered with. So that is the kind of test that you do in forensics. Each and every evidence will be unique. And if somebody interferes with the evidence and you calculate the hash value, they are going to be different. So our next session, we are going to look at introduction to digital. It has append this thing. We are going to look at introduction to digital forensics. We are going to explain the term digital forensics, compare digital forensics with the traditional forensic science, define at least 3 sub-branches of digital forensics, and then look at identify 4 steps in digital forensic examination, differentiate between the 2 categories of digital traces, and describe the digital forensics, how it can support investigations. Compare the 3 methods of how to recover deleted files and characterize different types of slack space. We know that digital forensic is part of forensic science, which is the study of any field as pertains to legal matters, which means that when you're doing any digital forensics examination, at the back of your mind, you know that this thing will end up in the court of law. Forensic science refers more specifically to evidence which meets stringent standards of reliability and scientific integrity for admissibility in the court. So, being part of the of forensic science, digital forensics is that branch of forensic science related to acquisition, processing, analysis, and reporting of digital evidence that is stored on computer systems, digital devices, and other storage media with an aim of admissibility in the court of law. So basically, what you're saying is that whatever you're doing will be brought to the court of law as evidence. Let's compare the traditional evidence with the digital evidence. One, you normally find this in the crime scene. I actually don't understand or know what that police is looking for. You have to secure crime scene in the physical world. Okay? Same thing in the digital world. When you go to a crime scene, you need to make sure that you secure it so that nobody interferes with with evidence. Okay? In analog, we have this. You don't want to contaminate the crime scene. In digital, we have this. We saw that how the right blocker, what is being used for, to make sure that you don't interfere or contaminate the crime scene, or the evidence. You have footprints in the analog world. In the digital world, we also have footprints. So anything that you do in the internet or in the digital system will leave a footprint. We have fingerprints. And we know very well in the whole world, nobody can have same fingerprints. Is that true? The whole world. In the digital world, I've just shown you the fingerprints. The SHA-1, SHA-2, MD5. Which means that any piece of evidence that you are going to bring to court will have a different fingerprint. And that is what now you use to ensure or to show the integrity of that particular piece of evidence. And that is why I said, if you've taken the bit-by-bit copy, then what you do, you calculate the fingerprints or the hash value of that, the original and the duplicate. If you do bit-by-bit copy, the fingerprints of the original and the fingerprints of the duplicate will be the same. So you keep the original, you work on the copy. Now, should anything happen, then you will have to create another fingerprint and compare. And this is why we just don't need to create only one copy. You create, according to the case, as many copies as you can. So that in case of anything, you create and you calculate the fingerprint. So fingerprint means that each and every evidence will have different fingerprint, just as the same into the world. So if you compare, the chances of one fingerprint in the analog world is 1 to 64 billion for you to get the same person with a single fingerprint. In the digital world, it is 1 to 340 billion. No evidence will have the same fingerprints. And that is what is important in the court of law, the integrity of that evidence. What are some of the branches of digital forensics? The oldest kid in this block is what we call the computer forensics. Computer forensics is the one which started when what you could only get evidence from our computers. Then as technology develops, we had for mobile phones. So it's a branch of digital forensics. Then we have network forensics. We have embedded forensics. Now in computer forensics, we talked about extracting evidence when the computer is off. That is what we call postmortem forensics, or sometimes we call it dead box forensics. You can have physical recovery of data. You can have live forensics, in which you extract data when that particular computer is on. Application forensics, you want to get what is in the applications of which is running on the computer. Multimedia forensics, and we have other devices like game consoles, those things that store data. Mobile forensics, the methodology of extracting data in computer forensics is different from the same methodology that you extract, but the principles remain the same. You have different tools to extract evidence from computer and different tools to extract from mobile phones. Network forensics, this is where as we communicate within the network, we are passing packets. Those packets can be evidence. So you need, if you, in that case, you need to capture them, diagnose those packets, and find the evidence that you are looking for. Then we have embedded forensics. This is where we, even now we have smart home forensics. Anything that is storing data, you might be called upon to extract evidence from that. We have electric cars nowadays, anything storing data. Even aeroplanes, you need to have, you can extract data from that. So category of digital forensics. We have what we call avoidable traces and unavoidable traces. Avoidable traces, this is the evidence that is in the computer, and the computer is configured to either restore that evidence, or computer can be configured not to store that evidence. This is the evidence that is controlled by the person who is having that computer. So they can store that, they can decide to store that evidence, or they can decide to even delete that evidence. So a suspect, for example, you take their evidence, their device. We have something like when you go to any website, it is cached on your computer. So if I go to www.els.org today, okay, tomorrow when I go to that site. By the time I start that EL, it has picked the els.org, because that information is stored on the computer. And you can decide to delete all the cache, whatever is in the cache memory, and you'll start afresh again. So those are the kind of avoidable evidence within the computer. So these are things like log files. You can configure the computer to store some log files, browser histories, browser caches. And then, on the other hand, we have unavoidable evidences. Now, unavoidable digital traces is what the computer or the device stores, whether you like it or not. You don't have authority over this unavoidable digital traces. So something like Slack, we are going to see Slack in the coming slide. Unallocated spaces. Things like MFT entries, if you're using Windows. Okay? The RAM, whatever is stored there, you cannot dictate. The computer will dictate. It's unavoidable traces, digital traces. What can digital forensics do for an investigator? All these are all browsers that you use. We have the internet history. So internet history, if you are using Mozilla, using Internet Explorer or Safari, or this is called what? And or Google. You can set them to store information that you need for your investigation. What can you get? You can get user-specific data. Programs that are being used by computer, website visited, search that are performed by that particular person. So this is user-specific data. You get as evidence that can help in the court of law. You can get what we call EXIF data, not EXIF data. When you have your camera and you are taking photo, the camera will record in that photo, on that metadata photo, of that photo, the type of camera that is used, the serial number, the model of that camera, If you enable location, it will record the location in which that photo was taken, and all that thing. That is called EXIF data in a photograph. Application data, you can get information from emails, clients, chat history, databases, configuration, malware analysis. You can get fragments of the files that have been deleted. Remember, I said that you can get an evidence which is a photo, but you only get the upper part of it. The lower part is not there. That's a fragment of a file. But it's an evidence. You can take it to the court, provided you wrap it properly, legally wrap it properly. Then you can take it to court. Evidential documents, things like account statement, blackmail letters, illegal pictures, all this can be found in the file. And then there's what we call inaccessible data. That is a hidden file or encrypted files, or deleted files, or steganized file. You can get there. But criminals use some techniques called steganography to hide the data that they are exchanging. Now, steganography means that you are taking, if you take a lemon right now and a white paper and use that lemon to write on that white paper and leave that light paper to dry, you will not see what you wrote in that light paper or white paper. But if you take a candle, you don't burn but just warm the back of that paper, whatever you wrote will be seen. The writer you wrote with the lemon will be seen. That's a technique of hiding information. So, for example, I wrote there, happy birthday. On this side, you can't see it, but when I hit it a little bit, I'll see what I have written, which means that I concealed this happy birthday so that it could not be seen. That's the techniques that the criminals use to hide data, what is called steganography. So what happens is that this criminal has got a gun, a picture of a gun. Maybe he's buying a gun for his colleagues, and he doesn't want to send that picture on a plain email. Okay? So they decide that they are going to resort to the steganography technique. And it is only them who knows how they are communicating. So what this guy does is he takes this picture of a gun and he conceals this picture on another picture. You can see the other picture is more of a holiday. Okay? So they take the picture of this gun, conceals it here, and sends it over. The other party gets that. The nice picture of the beach, and then that's what they know how to do, because they have agreed. And what they do, he gets the original picture. So they've been communicating throughout, but nobody can be able to know what they are communicating. They think that these guys are sending pictures about holidays. Maybe they want to go to this beach, but that beach picture has got something concealed in it, and that is how criminals hide the data. I asked, when you delete a file, is it deleted? Can somebody explain to me? I delete a file and I send it to the recycle bin. Is it deleted? Mm-hmm. What happened? How? Where is the microphone? When you delete a file from your hard drive, is it deleted? Explain to us.
You can recover the picture or the documents that you have put in the recycle bin.
But when you empty recycle bin,
I think you can get it.
how?
Okay, others can explain.
Saying others can explain. Who wants to take the mantle? Any explanation? Yes. That.
Once you delete the data from the cycle bin, as you said, which I see maybe from the slack space and the unallocated space. So the things you do, simple logic, what you do, you mark this data to be, you mark the space because this data has been now kept a memory from the hard disk. Once you delete, means you delete even from the, you shift delete, it means you say, hey guys, this is the free space to save it, but the data still resides into the storages. That's why it comes even the forensic. So a forensic guys has to make sure that you have to look from this residual data and an allocated space even to the slack spaces. Actually, this is how they do. This is actually, take an example from the physical carbon. You may say, okay, we said this particular space, we remove the data, but still under this, the whole, maybe you remove the address. Actually, you remove the address of this information, but doesn't mean that this data has been removed. So what you do, you change the address to be saved to another data onto the storages.
Okay, I think that's a good one. Now, computer has got a file system. Any operating system, computer has got operating system that is operating the computer, telling computers what to do, which means our software telling hardware what to do. Copy, they copy, delete, they delete. Now, computer stores, an operating system stores files like like a textbook. When you buy a textbook, what is the first place you see? Table of contents, right? So if you want any information, you check the table of contents. And the information that you'll get in the table of contents will tell you that this topic you are looking for is in the page 14. When you tear off the table of contents, is the contents deleted on the book? Is page 14 deleted? Page 14 is not deleted. Okay? So that is how the computer stores files. You have a file number, where it is stored, and the page. Okay? So you just go to that page and you get the information you want. Okay? So when you delete a file, it's like somebody who has teared off the table of contents, but the file remains. Okay? What happens is that the operating system tells the computer that we've deleted this file. So this space is free so that you can, if then any file comes, there's a place allocated for it. And the smallest space that a computer stores a file is called, what do you call it? I'm forgetting the name now. Sorry, I'm just talked so too much. That is this is a 512 space, okay, and a group of no, I'm getting forgetting. Sector, yeah, I'm just saying. The smallest space that a computer will store a file is called a sector. It's around 512 bytes, bits, I don't think bytes, yeah. So one sector cannot store the whole file. So a file is stored in a group of sectors called clusters, okay? So you can find that one file can occupy many clusters, okay? So if this file, for example, is that you are deleting is 3,000 kilobytes, okay? It is stored in a group of clusters. So you can see this sector has got this file, okay? And it's stored in all these sectors, and this becomes a cluster, okay? So the computer knows that this file is allocated from this sector to this sector, and this cluster, and this is the cluster, okay? So you can see that when you are storing a computer or a file, it will occupy all this sector until the end of this file. You can see that it has overlapped to another sector. However, that it is only taking very little space of this sector, which means that the rest of this sector is not going to be occupied by any file when you on this computer. So when you delete a file, what happens is that it tells the computer that from sector 1 to sector 5 or something like that, that place is free. So it depends on the file that you'll save next. When the file was 3,000 kilobytes, and you make it delete, it is deleted, and then you bring another file which is only 2,000 kilobytes. The operating system will write that file on the whole sector, but it will the other part of the cluster will remain. So which means that the original file is not only deleted, it's not deleted completely. There's part of it that has been overwritten, but the part of it that is still available. And that is why I say that you can recover using forensic tools only part of the file. If it's a picture, maybe half of it. This is what we call artifacts. So the rest of the place that is not occupied, like you see this one. I brought a file and it wrote up to this. So the rest of this was actually the original file, which you can recover. Is the original artifact. And that place is now called a slack space. Very important in digital forensics. So there's no file. If I bring now a file, which is 4,000 kilobytes, then I will not recover the original file because the whole of that space has been overwritten. Okay? So that's why when you're doing your recovery using forensic tools, you'll get those files that are half, but they are still evidence that you can still bring to court. So that is how a file, computer stores a file, yes.
What about formatting the device? When you format a computer or a mobile phone?
Formatting does not delete any file. It just restructure. Just restructure. And then tells you, okay, all this space is available. The only way to delete complete a file is what we call degaussing. you have to write that hard disk with zeros and ones, and you have to do it 7 times. That's how you wipe completely what is in that particular computer. There are tools that you can use for degaussing. Yes. So don't be happy that I've deleted it. The evidence is not there. It will be recovered.
I was wondering, is there at some point where you can no longer retrieve that file, or it stays there for as long as?
Yeah, that is what I explained, that I marked a file to be deleted. Have I deleted it? It's not deleted. The file was 3,000 kilobytes, all right? And now it is that space is marked for deletion. Before I save any file, that file will be recoverable. But if I bring a file which is 4,000 kilobytes, it's going to cover all that place. And in that case, you will not be able to get the original file. So these slack spaces will be so many when you're doing forensic investigation. Yes?
Thank you. Maybe to understand more what he has asked, for how long? Let's, for example, I have deleted the information that I've stored in my device, maybe for 400 kilobytes.
Mm-hmm.
Then I replace it with that one of 300 kilobytes, meaning that there is a space that can be retrieved for 100 kilobytes.
Mm-hmm.
Then for how long will it stay for any case to be recovered?
That space which is remaining is slack space. It will not be deleted. Yeah, because you can see it reached here, the new file. So the rest of this space is the slack space, which has got the other files, the original file. So that one will not be deleted.
Until when?
No, there's not an until well. That one can be you can recover that space. It will not be deleted only if this file reached this and covered the whole space. Then the original file is completely gone. There's no date, no time limit. When you are doing forensic, the first thing, acquisition. We've seen how acquisition is done. Then you process it. Then you do analysis, and then you do presentation. Some may have different wordings for that, but that's actually the process. Evidence acquisition. Evidence needs to be acquired. This can happen by collecting volatile data in search of during the seizure, or by acquiring suspect from a seized computer, or in any other process during a case where a case investigator needs to forensically acquire the data. Digital evidence submitted for examination should be maintained in such a way that the integrity of data is preserved. There's physical acquisition. That's what we saw, where you plug that device to prevent contamination, or you can do logical acquisition. Or logical acquisition is where you use that hardware, that black hardware has got the software version of it that you can use, and that comes with the forensic tool that you are using. We've seen that imaging or bit by bit copy. So you should attach it to this right blocker. Hashing is what I've explained. We've explained hashing, whereby you took data through mathematical algorithm that produce a complex alphanumeric string called hash value. So if somebody changes anything on the original data, the hash value will change, and you know that this data has been interfered with. Forensic analysis It requires the use of appropriate digital forensic tools or methods to uncover digital. Now, this is a process, and you need to use tools. Different devices need different tools. If you're using mobile device, you need a different set of tools. If you're using you're investigating laptops, you need a different type of tools. So some type of the digital forensic tools vary depending on the type of digital forensics investigation. So software application mainly based on investigative, case-specific to obtain complete, accurate results. Conducting an examination on the original evidence should be avoided as possible. Examination should be conducted on forensic copies. So tools and techniques used in digital forensics must be scientifically valid. That is proven to provide accurate results through empirical testing. Scientifically valid. So digital forensics must be reliable. That is, the same results must be obtained on different occasions using the same data, same tools, and same techniques. And they should also be repeatable and reproducible. Results are repeatable when the same digital forensic results are obtained with the same tests, items, equipment, laboratory, and operators. That is, it is repeatable. Results are reproducible when the same digital forensic results are obtained using the same test items, but different equipment, laboratory, and operators. So you need to put that into mind: reliability and repeatability and reproducibility. Upon completion of examination, the exhibit should be packaged and resealed, ensure integrity of the original data. Any further access should follow the legal procedures. Reporting your findings. Reports should be issued by examiner should address the requester's needs and document the scope and purpose of the examination. We'll see a good quality of report tomorrow when we are looking at reporting. It should give detailed description of the media, how you did the examination, includes any supplemental report related to the examination, provide examiner's name and date, authority in charge of the case, reference number, authorization court order, and things like that. Okay? So that is the last item that you need on a forensic examination. After you do this, that report you present it to the prosecutor, and always for the prosecutors and for the investigators, you need to work together. That is when you avoid confusion in court. But if you don't work together, you will not succeed. There's where I went to court. I did a report. We went to court at 8. I gave my report to the IO, who looked at my report. Then he served the defense lawyer with the report. It was only around 40-page report. Then the defense said, no, we prayed to the court that the court be adjourned and for 2 weeks so that he can get somebody to go and study that report. So so that after 2 weeks we come, and the judge granted his prayer. So I went back and came after 2 weeks, only to find this guy. I think he did not even look at the report, or if he looked at the report, he gave that report to, I think, an IT guy, because he came with an IT guy as an expert in court. So this guy, instead of asking me relevant question according to the report, he could not answer me anything. He just started trying to intimidate me so that I can agree to what he is saying, which I totally disagreed, and my report was adopted. Okay, so That's why it's important that you work very closely for prosecutor and the investigator, because prosecutor is the first recipient of the report. He needs to understand. He's not a technical person, but the person who has done the investigation must be able to educate him so that whenever he's presenting that, he knows exactly what he's doing. Any question? I think that brings us to the end of today's presentations. Is it useful? The content that you're getting, is it useful to you? So over to you.
Mwalimu, thank you so much to ascertain the veracity of your statement, your concluding statement of the usefulness of the information that you have given us today. Colleagues, tomorrow we'll start with a recap session. So we'll require each one of us to share with us briefly what you have picked from today's session. But I think it's been amazing. Thank you so much, Mwalimu. Personally, I've learned some new things. I've attended your trainings over and over, and every time I come, I keep learning. So the struggle continues. So colleagues, tomorrow we start registration at 8:30 to 9. So I think let's agree to be here by 8:30 prompt, so that we are able to conclude a bit early. Tomorrow we'll also be having the awarding ceremony, which will be held in this hall. So I implore you, as you come in, we'll have a separate registration sheet where we'll kindly request you to indicate the names in order of preference of how you want them to appear on your certificate. So tomorrow morning you'll find that list there, and we kindly request you to take off a few minutes and fill in that list. The other announcement I have is we are going to send you a link to a WhatsApp group probably this evening or tomorrow morning. If you have not yet joined, I don't know, has anyone joined the group yet? Okay, so we are creating a group of digital and forensic lawyers, and we are calling it the Rwanda cohort or the Rwanda chapter. And on this group, we'll be sharing all the material that Mwalimu has presented here, but also we'll use this group as a platform of continuous engagement and continuous learning. We've seen it work in Uganda, Kenya, and we have some success stories from people who have, litigated cases using Mwalimu Dinga's guidance. So that group will be set up tomorrow. And so thank you for today, and we look forward to seeing you tomorrow in large numbers. Thank you. Have a lovely evening. Yeah. I think we still have some tea outside if you would like to before you. Yeah, thank you.